Hi, this is Attorney Mike Grevin coming to you from Chicago as usual. And today we've got a fun one. We got a judge out in Kansas who gets himself in hot water. And joining me today, I've got Ron Coleman, who's been doing some of the Depp Heard stuff with me. Say hello, Ron.
How you guys doing? Nice to meet you. Your many viewers who have not previously been exposed to me. I'm looking forward to hanging out for a little while.
What is your practice area? We never got down to it because we're just talking about Depp Heard.
Yes. Well, so I'm a commercial litigator. I'm a partner in the Dillon Law Group, which is the main guy is a lady, Harmy Dillon, in San Francisco. She's very well known. She's on Tucker just about every week. She's a member of the Republican National Committee. We do a lot of free speech law and civil rights law. I myself have a background in trademark, and we stay busy and we have a pretty fun practice.
That's really cool. Where do you practice? Are you out in California? I thought you were in New York.
I am. I'm actually in Newark, but out my window, I can see New York.
Close enough.
Well, it's close enough, especially like if you can avoid going into New York in 2022, you do.
Yeah. It's got to be a mess. Although Chicago, the traffic is a lot less right now.
Oh yes, same thing with New York. But Chicago, I mean, I was never, I went to law school at Northwestern. Yeah. Oh, there she is. So I spent 3 years living, the law school's on Chicago Avenue near the hospital. So it wasn't like living in Evanston, which is just, the suburban lifestyle.
Oh, really? You went to Northwestern?
Yeah.
I'm just it's in Streeterville. That's where I took the bar exam.
At the university?
At Northwestern. That was just one of the sites for the bar exam in Chicago.
Was it in the law school? That's interesting. I didn't know there was a room big enough for that.
It was just like classrooms.
I get it. Yeah.
So they just split us up, and I went there. That's where I took the bar exam, and this was back in the day. I remember, my hand being cramped because this wasn't on a computer. We had to write this stuff out in blue books.
Absolutely.
All right. Now I can't find the clip I had. Just wait a second.
Oh my gosh. Okay. So let's keep vamping.
I think this is it.
Okay.
Here we go.
Oh my gosh.
The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome to all of you, both on the Zoom or within our court Zoom call, as well as those who are watching us on our Supreme Court Live channel. I will now ask Mr. Doug Shima, the Clerk of the Kansas Appellate Courts, to please call this afternoon's docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Thursday, October 28th, 2021 consists of one case. Appeal number 123911 in the matter of Marty K. Clark, Magistrate Judge, original action and judicial discipline. Your Honor, the examiner for the Commission on Judicial Conduct has reserved 5 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima.
First of all, it strikes me as odd that they're doing a hearing for the Supreme Court via Zoom, but that's what they're doing. It's pretty cool. And the guy bottom left, Todd Thompson, is effectively the prosecutor. The guy bottom center is basically the defense attorney. I mean, we're at the appellate level, so they're using different things, but I'm keeping it simple. Yep. And the guy bottom right is the judge who's in trouble here. That's the hot seat. Bottom right, hot water.
Counsel, will you please state your appearances?
May it please the court, I am Todd Thompson, appearing as examiner for the Commission on Judicial Conduct, present and ready for argument.
May it please the court, Chris Joseph, appearing on behalf of Judge Marty Clark, who is also present. I'm present, ready for argument.
Thank you, counsel. Mr. Thompson, you may begin your argument.
Thank you. This proceeding arises from a recommendation for judicial discipline from the Commission on Judicial Conduct.
A little bit of
The
discipline.
respondent in this matter is former Magistrate Judge Marty K. Clark.
This came up too. I like this stopwatch they have up here. Everyone kept asking us about this during the Depp Heard thing. They had a little clock up there, but this is a typical of appellate courts. I've never been to any Supreme Court. I haven't been to the Illinois Supreme Court, but I've been to the appellate court, and they give you, it's real specific on the time, just like this.
Well, I will tell you a fun little fact. In the United States Supreme Court, which I've had the occasion to appear before once,
Oh, that's cool.
there is an analog clock above the justices' heads.
Right.
But the rule is never look at the clock. I mean, if you're on your feet, don't look at the clock. You just
you better be on your game for that gig. That's a cool experience.
Okay.
From the 20th Judicial District. Judge Clark retired during his term of office after the initiation of this action. This case involves Judge Clark's participation in a website self-described as an online community for swingers and with regard to his related activities. Judge Clark posted nude and partially nude photographs of himself and others and gave access to others to view the photographs. Judge Clark maintained an account at this particular website on and off for multiple years. During the years of his subscription at the website, the judge paid the fees required by the website for giving access to others to the photos and information about the judge and his wife, and for gaining access to photos and information about other subscribers to the website. The website is used by subscribers for the purpose of connecting with other couples, which the judge describes as a dating website for couples. Some subscribers make connections that lead to sexual encounters. The account that was maintained by Judge Clark and his wife listed a false zip code and altered names, which we argued at the hearing before the panel revealed his awareness of the impropriety of his conduct. Judge Clark met the complainant and the complainant's wife in the late spring of 2019. They met at a bar, conversed, and after that meeting, Judge Clark and the complainant's wife began communicating via text message and email. I will refer to the...
Hi, Sean. Just to catch up, we got a judge that joined a swingers website. It's good times, and then a completely reasonable discussion breaks out here. So, but it is funny. This guy who's Todd Thompson, who's basically the prosecutor, is laying out a nice case, and he is so stern about this. It's beautiful. All the justices, to their credit, hold it in, but Justice Rosen, he never does, but he's on the verge of cracking the entire hearing.
Well, I mean, is there more to it where he does something on the website, or is it just the fact he did it?
Just the fact he did it. You shall see.
No, not just the membership. You, in order to be on this website, you gotta show the merchandise.
Okay.
Well, he took pictures of his junk and made it semi-available. These are all good questions. These are exact questions that come up here.
Hey, if he's proud enough to put it online, then he's not embarrassed.
But I assume that we're talking about judicial canons, right? Not just what.
Yeah.
But Sean, you're not going to get in any trouble for this.
Right.
No,
it's not illegal. This is an ethics.
Yeah,
this comes up from an ethics violation.
Oh no, I know this is a judicial disciplinary hearing, but it's like still, it's like.
Yeah. I know, and I get this all the time from people who are upset with me, and they say, "Oh, the attorneys and judges are above the law." No, we've got more restraints on us than anybody. Believe me.
I mean, if he's on Tinder, would they be as mad?
I hope not.
The judge's paramour from this point forward. The judge and his paramour discussed in very graphic terms their attraction to each other and the prospect of having sexual activities with each other. Their rather salacious texts included messages wherein Judge Clark and his paramour actually discussed the details of a wished-for sexual encounter in the judge's chambers.
Can I ask you about one of those exhibits? And I won't get into the details of the dialogue that was occurring, but it's graphic as you described. One of the
we can all imagine, but thanks, Judge.
No, Justice Rose is like, can we actually talk about these text messages? And by the way, I'm losing internet connection. I'm gonna have to dump my video for a minute. Just tell me about it. No, that's what he's saying. Go through it slowly, though.
I don't know. Maybe it's because I practice law, but I don't find anything hot about judges' chambers. Let's just start there. It's everyone teach their own, but it's just not on my list.
questions I have is that it appears that it has a time stamp on the time in which the texting was taking place, and it says 2:16 p.m., and I assume that's in the afternoon. And then one of the text responses referred to, I should not be wound up on a Tuesday. Can we infer from that that was occurring during work? Oh. Or what do we take from that? And if we can, does that make a difference?
I don't know that it makes a difference, although it might make it worse. You can take that there were texts because there was evidence before the panel of the timing of the text. The text occurred during the day. The judge denied that it ever interfered with his performing his duties, but with
Oh yeah, I mean he's dropping this text in the middle of somebody whining on about some bad motion for summary judgment that he doesn't want to listen to.
Oh, okay, that's an issue.
Bench?
That's an issue.
Was he on the bench? No, it was.
Well, I guess it's during work hours. The rest I'm kind of putting, but that's the text message. I shouldn't be this wound up on a Tuesday. Tuesday during business hours, he's probably on the bench.
I wasn't aware that Tuesdays were a day that was set aside, though. As a man, I feel, especially at my age, anytime you can get wound up, you don't quibble about.
Good for him. He should get a commendation.
Yeah, this is like the Massachusetts Bay Colony Bar Association, I think, at this point. He doth thought about fornication.
Well,
instead of carrying out the good Lord's work.
Well, we're talking about adultery here, though. So this is a little bit.
You guys are both going to like the justices' questions. You really are.
Without question, they were texting back and forth during the court's business days.
All right, we got you.
Going on, I would note that during this discussion about having sex in his chambers, Judge Clark readily identified his chambers as being in Russell, Kansas. Photographs of Judge Clark, most of which had been stored on the subject website in the judge's profile, were admitted into evidence. Those photographs have been sealed or were sealed by the panel.
Counsel?
Yes.
I'm sorry to interrupt you, but your time's running down. And
I like this guy.
I guess my question, I'm trying to think how to frame this appropriately. And I guess the question is,
that ship has sailed, man.
Do you have any concern that this proceeding is treading inappropriately into the private life of the judge? I'm just trying to, is the recommendation of discipline and the violations entirely founded on the moral disapproval of this behavior, or is there something else?
Chris
I guess
Jones
that's the
nodding
right
his head.
question to ask.
That's where he wants to take this.
Well, I would note for starters, this court's opinion released in February of this year, indicating that Canon 1, Rule 1.2 demands that a judge act at all times, meaning 24, and I'm quoting the opinion now, meaning 24 hours a day, 7 days a week, 365 days a year, in a manner that promotes public confidence in the independence, integrity, and impartiality of the jury, or of the judiciary.
And is that, so what is the standard that we apply to entirely private behavior? I'm trying to figure out if
because
this
he
case
disagrees
has any kind of
about being on the clock 24 hours a
standard,
day.
or
Now that
if
we've
this
ruined
is
this guy's
just
life
all of
completely.
this.
Yeah, I mean, I don't know a judge alive that could withstand that scrutiny. I'm sure he's citing a rule, but
he is. Yeah,
you're saying that nobody does anything that wouldn't, promote the respect of the judiciary 24/7, 365. No way.
What happened on the bench alone?
Yeah.
I mean, you don't have to come on to private life.
Sure.
Right.
And I think the funny thing is these, the Supreme Court justices, if, when he says it's like, oh, you're always on the clock, I bet they're all thinking like, yeah, no, we disagree, boss.
Meanwhile, every one of them is currently a judge or a justice in the Supreme Court, and they're thinking, they're pondering, have I done anything that's not that I would not want?
Any way for me to erase my browser history while we're doing this hearing?
Yeah,
as we speak.
Right,
well, this is where he should have
details.
said, like, the guy investigating should have said, Your Honors, I demand you all stand up. I want to know who's wearing pants.
Right.
Which are unpleasant, I'll say, have come to light, and it embarrasses the judicial branch, and that's the grounds on which we're going to find a violation.
Well, I would argue that these details are not private. That's why these photographs were at a public hearing. That hearing was public. The decision was made not to, or to seal them so that they wouldn't be circulated in the public. But a complaint came in from a member of the public, so it's not private. Second, the judge is subjecting himself, when he engages in this type of conduct, to the possibility of being intimidated or blackmailed by people who have these photographs.
And there's your
in
problem.
this particular instance, the complainant opted to
How far does this extend? And let's just,
That's a
and
rather
again, it's
personal
unpleasant to talk about this, of course.
If they hadn't sealed it, he would know the answer, I guess.
Yep.
Well, this is where it's like,
That's my double entendre.
maybe there's a blackmail, but if this dude's got like a monster hog, hey, Judge, we're going to tell the world you got a big
favor.
Yeah, Judge, we're going to tell the world you got a big cock. It's like, oh no, don't do that.
Family, come on, man. I'm a rabbi. Come on.
Oh, I'm sorry, Ron. I'm sorry, but like,
it's happy hour. It's happy hour. Let's talk with Mike.
So I want to say, Mike, you may know this, and I jumped in a little late. When he took his pictures, did he refer to like, oh, by the way, I'm a judge in Pig Knuckle County, Kansas, or something?
No, he said they were talking about doing it in chambers.
Well, no, I know that. But like in his profile, like my swinger profile, like, by the way, I'm the judge here,
Right.
I'll give you some justice.
I thankfully did not see the swinger profile.
Oh, all right. Well, I didn't know if they alluded to it or not. But
let's assume that a judge is having an affair, an old-fashioned affair, if I can call it that. Is that enough by itself?
A good American old-fashioned
to find a violation?
I think
Justice absolutely lapping.
You probably need a little more detail, meat on the bones, but yes, I think it's quite.
Why do you need more? Isn't that judge also subjecting him or herself to public embarrassment, blackmail, all those other kinds of things? So under the logic of the way this case has been prosecuted, I'm finding a hard time distinguishing that hypothetical.
Well, I don't think you need to distinguish that hypothetical. There is case law cited in the record that says, for example, adultery in Connecticut. There's a Connecticut case cited. Adultery is not a criminal act in any way, but the court has held it still can create a situation where the judge is vulnerable, and it can create a blemish on the judiciary.
So and again, I appreciate the straightforward answer. I'm just exploring where these lines are, but it sounds as though the position you've taken is that judges are held to...
You held what?
I suppose the right way to say it is the standard, the broadly acceptable standard of private behavior, especially with respect to their sexual lives. Is that a fair way to say that?
I don't know that I'd say especially with respect to their sexual life. I just think if you accept wearing the robe, you accept restrictions on how you can behave, and that you have to act.
We would all agree with that. What we're trying to discern is what those restrictions precisely are.
Well, again, it has to promote public confidence.
That's not going to happen.
Does this kind of behavior promote public confidence? Absolutely not. Does an as you called it, old-timey affair or old-fashioned affair promote public confidence? Absolutely not. Does it endanger the independence of the judiciary? It absolutely does. And I see my time is up.
Thankfully for you.
Are there other questions?
Counsel, it used to be that drinking liquor in public was verboten. It was very dimly viewed by the public. How do we ascertain those societal mores other than simply to look within ourselves?
Well, I think you have to look into yourselves and society. You need to get out more. But I mean, we all have.
I wish I could do it
slightly different.
Thanks for coming by, Ron.
Sorry,
Appreciate
Ron.
it.
Yeah.
I'm not saying that there's a red line that is the same for everybody, but we all have standards that we think are appropriate or inappropriate behavior. And the good news is, in this particular case, we're not even close to the line. We're so far beyond the line that the panel voted unanimously. It wasn't like it was vague or uncertain here. So I don't want to get caught up in a academic discussion that is not necessary in this particular case.
But the bottom line is, the conclusion of the panel is that the conduct in question violated the code because it was so far afield from the established line, which is some moral compass. And I think the questions that I've heard today, I'm echoing perhaps, but that moral compass, are you suggesting it's just, you know it when you see it, or are there factors that can guide our discretion in identifying what that moral compass is?
Well, I don't think I use the term moral compass because I'm not sure this is just a matter of morals. I think it's something different than that. Again, I think the question is, does this kind of behavior promote the public's confidence in the judiciary, or does it detract from that? My conclusion and the panel's conclusion, it very much detracts from that. That's not a moral decision. That's an awareness of how the public reacts to this kind of behavior. Does it promote the independence and integrity of the judiciary? I mean, these are the terms from the code. Again, absolutely not. There's nothing about this behavior that makes you think this judge is above reproach, or that this judge might not be intimidated or blackmailed by someone who has possession of these photographs. So that in turn impairs that judge's potential impartiality. So all of these dominoes fall over when this behavior occurs. And again, I don't think this is just a mere where are your morals. There are some standards set forth in the code.
There are other questions. Thank you, Mr. Thompson. Mr. Joseph?
That actually shocked me when he gave his opening statement, said what happened. I thought the court would just roll over, but this guy got grilled by them.
Yeah, I mean, like, all the jokes aside, could there theoretically be some blackmail? Maybe, but it also, he's going to be involved, like, no matter what you do. Let's say he's involved in the Freemasons, or let's say he was doing this on the down low and he wasn't using the internet. Like, if somebody still finds out about it and then goes, like, runs and like, oh my God, he could be blackmailed for this. Like, he could be part of, like, I don't know, a stamp collecting club, and everybody like, oh my God, he's such a dork. Like, there's a million things he can do. Like, and I think we all have something that, like, it's kind of like a guilty pleasure, and if we told the whole world about it, it'd be kind of embarrassing. And, like, I'm not going to lie, when I first started doing this, this was kind of like, I was kind of a little bit embarrassed by it. So, like, the one time my girlfriend told, my parents, like, I was doing this, I'm like, shut the fuck up. Like it's not good. But, like, but everything is embarrassing to somebody at some point. But, like, let's say we found him on Tinder.
Oh, I mean,
and let's say he had, like, the most chatted, like, this guy looks like at least he thinks he's a Chad. He probably would have, like, the chattest profile. Like, if you're under, if you don't make X, swipe left, just keep swiping, ladies. Yeah.
No, you're right. I mean, there's lots of judges engaging in this behavior, but they didn't put themselves in position. They didn't put out pictures. That's really the issue here.
But that then this turns into more of, it's not that you did it, but it's you drew the attention onto us, which that shouldn't be the way that shouldn't be the disciplinary reason, because then it turns into, if you stay quiet, it's okay. Well, no, either it's okay when you're quiet or you're out and loud doing it, or it's not okay. Like, it's not okay, period, is, I think, the real argument here.
It's a tough one. Yeah. I mean, for instance, they brought up the issue of extramarital affairs. I mean, there are people across all professions all over the place who are doing that. Yeah, and have for forever. Joe, how you doing, buddy?
Hi, Joe.
Hey, Mike. Hey, Sean. How you guys doing?
We got a swinging judge here.
Yeah.
What's that even mean?
Like,
I have so many ways to interpret that statement.
Pictures of his
no. Like, he's literally he's like, he's a swinger.
Is that really what you're talking about?
He's a swinger in one of the worst places. He's in front of the
Kansas
Supreme Court on this issue, and believe it or not, they seem to be kind of okay with it.
What? That's Honorary Marty Clark. That's the swinger.
Yeah. Bottom right. That he's the guy in the hot seat.
Well, he's the guy not wearing. He's a judge who's not wearing robes, so that's why I assumed.
Yeah, he's having a bad day.
So he's having a bad.
May it please the court. I believe I'm somewhat limited by the fact that Judge Clark decided not to file exceptions in this case after he retired. I do, however, want to address Justice Reagan's.
Let me just address that. No exceptions were filed. So really what we are here on is the appropriate discipline. Isn't that right, Mr. Joseph?
Unfortunately, I think that's what Rule 620 limits me to.
Well, no, it's not unfortunately. That's where we're at, isn't it?
Ooh.
Well, to me, it's unfortunate because I think the court has a can of worms and the potential to set some really bad precedent.
But I want to understand the posture of the case is we're here on what is the appropriate sanction in this matter.
That is correct.
Okay,
Rule 620D limits me to talking about, I can make a statement with respect to the disposition of the case only. I do think, Justice, and I was going to address your question, that it would be appropriate for me to answer your question.
That's fine. I in preparing for this, I saw that, and my question was, seeing the time and the day in question seemed to imply that this was during possibly, or I think the assumption I had was this was during work hours.
Right. And that would provide the connection that you see in the other cases where there's discipline, some connection to workplace conduct. I just wanted to point out that is in the record. That was addressed at the panel hearing. It was not a day when Judge Clark was working. He was not in the office. It certainly wasn't established by clear and convincing evidence that he was. So I think that what you were searching for perhaps was the hook between pure morality standard and some connection to his office. And the only
I wasn't necessarily searching. It just stood out to me. Okay. Thank you.
Understood. So because of Rule 620, I am limited, as you mentioned, just talking about disposition. And the only comments I have is, I mean, he has since retired. So removal and suspension become irrelevant. The panel recommended public censure.
Mr. Joseph,
Yes.
do you have a position on whether or not this court has jurisdiction to impose any discipline, including censure, on a person who is no longer a judge?
That justice wants no part of this. He does not like this at all. And the guy before arguing said that the committee below, it was a unanimous vote to for discipline. But he's got this guy in his team.
Wow. It's a good question. Being limited by 620, I didn't plan on researching or arguing.
Well, to me, that's entirely within the ambit of discipline.
Yeah, I want to get like a little more context so I can like fully appreciate this. And maybe some people join late also, so perhaps it'll help them. But at least it'll help me so I can like weigh in a little more intelligently. So
okay.
This guy Clark here, during work hours, while he was not on duty, was engaged in swing festivities with a bunch of fellow swingers.
Well, what we have before us is that he was texting back and forth, and he was exchanging texts on a Tuesday, which we presume is during business hours.
Okay, and he's no longer a judge?
He's no longer a judge. He I think it looks like he retired in shame out of once this came to light, kind of thing.
Okay, yeah. So which is. All right, it's an interesting thing. You could see a parallel to the second impeachment of as far as like now that he's gone, can we go after him and that sort of thing. Like that whole parallel there, which is an interesting concept because I guess if he wanted to come back at some point, unretire, so in that case maybe he's relevant, which is the same thing that we dealt with Trump.
Yeah.
And he so this panel this guy Todd Thompson, he's the one who's the complaining.
He's the prosecutor. Yeah. Chris Joseph is his attorney.
Is there a morality statute or something guideline that he purportedly breached?
It's an ethics because he's a judge, so it was an ethics complaint.
But is there something written that they say you violated ethics rule XYZ? So it's a general morality clause. So my question is there something saying specifically you cannot do something like this during work hours? Is there something saying you can't do this in general?
There's something that says equivalently. Basically, I'm paraphrasing, but it's unbecoming for a judge to engage in this activity. So basic sort of ethics complaint stuff.
Yeah, and his argument is also like when you're the judge all the time, and that 24 hours a day. Your conduct should be governed accordingly to instill public trust and all that.
Which is definitely a fair position. I don't think that.
When he said
Americans take that position or not. It's an interesting position.
Yep. Well, when he said that though, the 7 people above him did not seem to nod their head. So,
they didn't. They were basically like
that shocked me. This guy laid out a nice case, and they weren't like rude or anything. They we respect that position, and then they just hammered him with questions.
Yeah,
as Thompson, they got him hammered.
Yeah. They're all on him. We're delving too deep into this guy's private life here,
and basically they don't want their own private lives being
absolutely,
investigated.
Absolutely.
This is totally a survival, self-interest type of thing.
Absolutely.
Yeah. And I think it's an important question whether or not someone who's no longer a judge, because the code, by its terms at least, only applies to judges. It doesn't apply to retired.
Right. And particularly Judge Clark is not an attorney as well. He is a lay judge. So he is done. He's not going to practice. You can't. Some judges, there's a concern.
Oh, I didn't catch that. They said he's a lay judge, so I guess he's a magistrate. So this is like a low-level guy. So I guess what they're saying is, well, you know, there's really no ethics complaint for the purpose of like his bar. Like, you know, if I was a judge and just retired, I'm still an attorney.
Oh, wait. So, oh, no, they said he's not. Oh, I guess
he just said lay judge. I didn't catch that the first time through.
Wow. So,
and
okay.
I mean,
I can't stand that where places let you be a magistrate without actually having a law degree.
I know, and every phrase that comes out of their mouth sounds bad in this context, and lay judge isn't working either.
Yeah.
Are you saying?
That's a.
I like that. The swinging lay judge.
The swinging lay judge. I might have to change the the thumbnail.
If they leave the bench, then become a practicing lawyer, and that is a hook, if you will, to keep jurisdiction over him. That would not be present in this case. Judge Clark is retired and not returning to the practice of law because he's not a licensed lawyer. I think the court can do whatever it wants to do under the rule. You can find no violation and dismiss it. You can impose any of the discipline options, or you can find there's no jurisdiction because he has since retired and is no longer. There's no possible future conduct. So yes, I agree that is an issue. One which I didn't brief again because we didn't file anything. We didn't have any exceptions to make. My only suggestion in terms of disposition, if the court does accept the panel's recommendation for public censure, I would encourage the court to craft this in a way that does not set precedent that becomes an unfortunate precedent for future issues that might come before the panel on questions of morality. I think Justice Wilson pointed out correctly that drinking was a moral objection. Homosexuality was a moral objection, both of which you could write language following this panel's rulings that could create something that's troubling for future generations based on what I see to be a reasonable person standard the panel suggests for determining morality. So whatever you do, my only suggestion, if you take the public censure route, to craft this in a narrow way that does not create problems for things that may seem problematic to a reasonable person in 2021, such as drinking or homosexuality used to be a problem morality-wise 30, 40, 50 years ago. I don't want the court to create something that's a problem for us, the generation appearing, my kids appearing before the court in 2050.
Counsel?
But go ahead, Justice Wilson.
Counsel, but isn't it appropriate for the court to look at what the societal mores and expectations and accoutrements are at this time as opposed to what they were 50 years ago?
So the issue to me is when is discipline appropriate? And I presented my arguments to the panel and they disagreed, but my response to you would be the same as was the panel, which is you don't know. I don't think you look at morality as a basis, especially some of these private sexual morality as a basis for discipline, unless, like these other cases, and why I referenced Justice Rosen's question, unless there is a connection to the job. And you'll see all the cases cited in the briefing, there's always some kind of hook to that, such as pornography while at work, such as saying something to a clerk or showing a picture to a clerk who works for the court. Things that aren't present in this case because that Tuesday was not a work day.
I think, counsel, mores are different from morality. I think mores is a broader concept of just general expectations of how society expects people to act and whether or not there's some objective line or some clue that we can use.
It's dangerous to try to do that. I'm not. My position is the court shouldn't venture into that realm. It's dangerous to do. Again, 50 years ago, homosexuality would have offended most folks in society, and it shouldn't. It should not be a basis. If it is a private life with no hook to his role as a judge. Again, I don't want to try to tread upon Rule 620 and try to backdoor in arguments, because we did accept. We did not file exceptions. But I do think it's a slippery slope. So to the extent that you do craft public censure, I do worry about setting precedent that becomes a problem. That this reasonable person standard is awfully difficult to apply. And who is the reasonable person? Is the reasonable person a member of a small religious community in Southwest Kansas? Is it the broad state of Kansas? Who is this reasonable person that sets these mores or morality standards? And I don't know that you can do that. It does become a slippery slope issue.
I appreciate that you're trying hard not to tread beyond where you should go, but maybe our questions are pushing you that way. And since there's time on the clock,
Sure.
The question occurs to me, it's a policy question really. When we ask these questions of mores or morality, does it make a difference that this judicial position is a publicly elected one?
Well, you'll see in the case law, there are many of the cases that were cited and discussed in our briefing where, for example, Pennsylvania and some other courts who have considered affairs and morality suggested that there should be a line that doesn't go to this particular question. It just shouldn't be part of discipline because these are better resolved at the ballot box. For example, if
right, the idea is if his constituents don't like it, they can vote him out.
Right. And several courts have taken that position. It seems informed. I like that position. The other position that I like quite a bit is that without some kind of hook that ties the conduct into the judiciary, you shouldn't be going there at all. In this case, you had a complaint by a resident of Missouri. It's not, there's no conduct that involved work. Because of that, if that Tuesday at 2:16, if Mr. Thompson had established by clear and convincing evidence that Judge Clark was working that day, you'd have that hook. You'd have something there. But he wasn't there. It was a private personal phone. He was out of the office. There really is no connection other than the woman with whom he did not actually have an affair, suggesting something would be some fantasy of being in chambers at one point, again, on his private personal phone text message. So there's no hook that ties it into his role as a judge. And frankly, when you're looking at strictly questions of morality, those can be resolved at the ballot box or, otherwise if he is out of sync with the standards of his community.
Counsel, in Ray Romy, the judge made fun of a prostitute during sentencing by giving her sentencing in verse. And in that case, it was found that that behavior was so egregious that he was removed from office. Later on, he was elected by the voters to that very office. So I would argue that both the court and the voters exercised their discretion in attempting to do their job as they saw fit. Can you distinguish that case from this situation?
Yeah, absolutely, because what you've described again is conduct related to his performance of his job. If Judge Clark had made inappropriate comments, not even just in chambers, but at the courthouse, there's something tying it into the job. Here it is completely private, personal, out-of-court behavior. There's nothing tying it into his role as a judge. He didn't even do it during the work hours. This is regulating the bedroom, essentially.
I have a question. Let's take morality out of it, okay? Let's not even talk about morals. Let's talk about that the complainant in this case opted to file a complaint instead of posting this picture that he had in his possession of the judge naked or body parts, and instead posted that on his Instagram account and it went viral. Does that affect, as the code says, public confidence in the judiciary or promoting integrity?
That really gets into the blackmail issue, if you will.
I was saying this earlier. Ron was here earlier, and I was saying this. I came at this clip with the worst of intentions. I thought, okay, this is salacious. I'm going to have fun. And then I started watching it, and I'm like, it's really interesting. Both attorneys present great cases. The justices are asking great questions, and it's an interesting discussion.
Yes.
It is. It's a very interesting discussion.
Well, and I think that judge does bring up a good point. Like, if we discipline a judge, but the people of that community say, actually, we're cool with this, what does that say? Yep. And I do think that's an interesting issue.
Well, what do you guys think? Do you think that morality should be legislated with respect to our, people who are holding public office? And is there a difference between judges and politicians? Is there a difference? Like, should this sort of thing be legislated, or should that be left exclusively to the ballot box?
Yeah, I mean, these are all good questions. And like, for instance, with politicians, they're nowhere close to this standard on average.
Yes.
So this is definitely trying to raise it for a judge, but this is a wrinkle I didn't get, that he's a lay judge, so he's not.
Yeah.
He's not even a member of the bar.
So yeah, you can't really discipline a guy. Like, what are you going to do? Take my law license away? Yeah.
Well, then this justice asks a damn good question, because they have me convinced. Let's stay out of his bedroom, whatever. Let the guy go. Then she says, okay, fine. What if he posts it on Instagram and gets 10,000 likes? Does that change your analysis? I mean, these are uncomfortable, rough hypotheticals.
Yeah. No,
they really are.
I'll tell you this much. Here's my starting. I have a couple of starting points here. Okay, I recognize that if I were to use my own personal morality standards for who should be a judge, there probably would be like a dozen people eligible.
Right.
So when I'm trying to approach this, I remove my personal perspectives on things, because I recognize that's not a fair yardstick to hold society to at large, and that society has different values than I have, and I'm not the one in control of society. And I think each of us might have different values, in certain areas of society at large. So it's sort of important to step out of that and just look at, what's right or wrong in the abstract rather than from a personal perspective. And with that in mind, to me, it makes sense to sort of try and draw a line based on a few factors here. If the judge is someone who's using his position in order to promote something that's considered salacious, like imagine a situation where he's like in his courtroom and doing involved in lewd or lascivious type of activity. Right. That's something that I think that certainly now you're basically using your position to embarrass the structure of the judiciary. So that I would think that they can come down very hard on that, and should. Even if he refers to himself as like, the judge, here comes the judge in some sort of sexual type of way. I think that is, he's now at that point, if he himself is choosing that rather than the third party attaching it to him. But I think if he himself is embracing that sort of perspective, that is someone who is basically embarrassing the judiciary and certainly is asking for sanction. But let's just say he or she would be acting in an individual capacity and almost hiding the fact as far as their role in the judiciary and things of that nature. While I personally might frown on that activity and think it's bad, I don't think our society at large probably frowns on it nearly to the same degree that I would. And I have to recognize that, all right, most people are looking at might not even realize this person has anything to do with the judiciary.
Right.
So, and whether he sends it to 10 people and it stays with those 10 people, or whether he sends 10 people and it ends up going viral, I don't think there should be a difference, because his conduct, his activity, as far as what he sent it out, I don't think the virality of the share should play a factor at all.
Yeah.
Because you cannot control what's going to go viral. And it's very hard to know or gauge. And just because I sent to 3 people and some of them end up jacking it up and it does go viral, that shouldn't mean that I get more of a punishment than someone else does the exact same activity to me and it stays relatively quiet. I don't see how that's a fair factor to even bring into the equation, personally.
No, that's interesting. And that is a big difference between now and, say, even 10 years ago.
Yes, it's for sure. But we have to carve rules going forward, not looking backwards. So
But we're all hip to that because we're YouTubing here.
Yeah.
I mean, as
No,
well as
I'm not talking about blackmail. I'm talking about the reflection on the judiciary. And you could say also, if I post a Twitter, a tweet that says F the president.
Sure.
In my own time, on my own phone, on my own private Twitter account. Does that reflect well on the judiciary? Does that promote integrity and public confidence in the judiciary?
No, I agree that's a bad set of facts and you don't want that. Likewise, if somebody hacked into your phone and took one of your private pictures off, which unfortunately can happen, and posted
That's
that,
not what
that
happened
would be...
here. What happened here
I
was
understand.
intentional putting out there
Sure.
for public dissemination.
No, it was as if I sent a naked picture to my wife.
Isn't it foreseeable? Well, no. Wouldn't it
It
be
is.
foreseeable that somebody would, don't we do
He's
that
totally
all the
sent
time
a
on
naked
social
picture to
media?
his wife.
Realize that if you post something,
That was
it's out
confession.
This was not on social media. This was
But if
only
you
one
text,
person.
the old adage of don't.
That sample really was a little too natural, wasn't it?
Yeah,
Yes, that was a self-report.
Yeah, he's like, suppose I sent a picture.
For sure.
Suppose I sent a naked picture to my wife while I was on a chin-up bar, and I was like, some were going down, some were going up. One time I had my leg up in the air. Like, what are you telling us?
Yes.
What the hell?
And suppose my wife responded back with a bunch of volcanoes.
Don't write anything down that you wouldn't want on the front page of the Wichita Eagle.
Oh,
No, I agree. It is risky in the sense, but it's also likewise risky if you send a naked picture to your wife. The same risk attaches. I mean,
Right.
this very well could have. I mean, whether or not it is. I mean, it's essentially what you tell your kids. Don't take naked pictures of yourself. Don't do these things because don't write an email. No, I agree with that. It's not wise because there can be issues. That said, where does the court come in? If it wasn't posted anywhere, the only reason this became a matter of public knowledge is because it went to hearing, and here we are. Otherwise, it wouldn't have been.
A member of the public complained about it.
Yeah, to Mr. Thompson, who put the pictures in the record. Yeah, otherwise nobody would have heard about it.
Well, wait a minute, counsel. That's not the finding of the panel. At the top of page 12 of the final hearing report, it says, the respondent's decision to take a picture of his penis and post that picture on a social media website crossed that bright line and violated the judicial canons requiring a judge to act with integrity. And earlier in the decision, the panel specifically rejected your argument that this was not public. And so this case has got to boil down based on the findings to being the posting of these private pictures on social media that was more widely available than just you're sending a picture to your wife. And that's why I think so much of this discussion is off base.
I'd push back on that, Justice. I don't think those aren't the facts. I mean, literally,
That's right.
it
Push
is
back
a
hard.
website, but the only people that had access to this was the respondent and his wife. I mean, so it literally, you have to grant access. These are the facts in the record. The panel characterized it, and I see the language you're talking about it. I mean, they're calling it a social. The only people, if you go to the record and the facts, the only people that have access to this, the respondent and his wife. Nobody else can have access to this.
And those to whom they gave consent to have it released to you, is that correct?
The respondent and wife, yes. The respondent and his wife, or not the respondent, I'm sorry. The complainant and his wife were given access by the respondent and his wife. So Judge Clark gave authority to the complainant's wife and the complainant to access the photograph. So this is two couples that had access to it.
I appreciate
And
the
this is
fact
so at
So
the
you got
top
knocked
of
out by a
page
buddy. Jeez.
I appreciate the fact
11,
that Justice Wall
the
seems to be
panel
quietly assessing
specifically
the
says the respondent cannot hide behind a claim that these were not public because he was the only person who could give permission. The respondent opened the door by releasing the photos to even one person on social media. Those photos could be generally disseminated to social media world and even finding their way to the commission. So again, I think really both sides keep wanting to keep talking about moral compasses and moral codes. This case has got to boil down to the fact of using social media for this function.
Those aren't the facts, Justice. I mean, it's the same.
That's what we're talking about, though, right there. I mean, all this is funny, and I'm having a nice immature laugh about it. But damn, if they aren't on point and like hitting all the issues, it's impressive. It really is, and it's the Supreme Court via Zoom, but still, it's cool.
Yeah,
I read the language that they're using in there to mean. I mean, they didn't change the facts; those are the facts. What I read that paragraph is saying is the same as I'm creating the ability to, if I send a naked picture to my wife and she gets mad at me and files for divorce, and that's the revenge porn legislation that's out there, she could then post it on Twitter. I mean, you're creating this
Mr. Joseph,
same scenario.
Justice Biles
That's actually
drew our attention to the exact language in the from the panel that I have at least conceptual concern with. The language about respondent can't hide behind the notion that this wasn't public. I'm wondering if that's even right as a matter of law, because that standard suggests that there's no such thing as privacy at all in any two-way communication. So every email I've ever sent, every text message I've ever sent is now public. I don't know how we escape that conclusion from the panel's conclusion, and that would be very troubling to me.
I think you can use the same language, and this is what I said to the panel. Again, they didn't agree with me, so I acknowledge that. You can use the same language and same description if I send a naked picture of myself to my wife by text and she later posted.
Well, it might help to take naked pictures out of the... what if I just say, I'll meet you for lunch at 12 p.m. at the Classic Bean or wherever, downtown Topeka, and I send that to whomever in a private text or email. According to the panel's findings, that email is public, right? Would you agree or disagree?
No, I agree. No, I agree. Anything you send, there's a potential that it can be, I'm essentially saying the potential that it is later disseminated exists. You put it in writing, you send it to someone, therefore it could be disseminated on a public forum later. That everything's that way, whether or not it's a naked picture or I'll meet you for lunch. It is a communication, while private between two people. It could be later revealed to the public at large. You cannot hide behind that, if you will, is the conclusion of the panel.
Yep.
Mike, I gotta bust out of here. But
thank you for coming by.
I mean, it's my pleasure, my privilege. This is a really interesting conversation. I hate that I have to duck out, but
see you, Joe.
Not a problem.
Yeah, no, thank you so much for having me. I look forward to catching you really soon.
Thank you, Joe.
Yep.
Mr. Joseph, I assume from your argument.
History.
What's that?
Hope Joe's not going to purchase history.
That your recommendation of the court would be to impose no discipline?
Yes, yes, it would be.
Just to make that clear. Are there other questions? Mr. Thompson, you reserve 5 minutes.
Thank you. There's been a discussion about
I know appeal to co-counsel
bad
Pat Robertson
precedent or precedent that would cause a problem in the future.
This guy is, and by the way, I think both attorneys and all the justices look great here. I think it's a really intelligent discussion.
Yes.
Good advocacy all around. But this guy is straight from central casting for the moral position, you know?
Yes. I'd
be like, yeah, I'll pick him. Yep.
Yeah, no, and I would agree 100% with that. The justices, I mean, I didn't think they'd be any different here, but these two attorneys are, yeah, I mean, I'd say his argument, though, is the closest to straying into, like, you know, arguing for feels versus the facts here. But yeah, it's, I still come down to the idea of, like, how do you discipline somebody you really don't have authority over?
Yep.
Really, at the end of the day, because
And
what
they
can
address
they
that
force
issue,
them to do? Yeah.
and they address the whole issue of, well, the real problems here is that social media and it can be reshared is essentially the issue.
Yeah.
And they come to the issue of privacy versus that, but there are really good arguments about blackmail and community. You know, it's a touchy issue. The end.
Yeah. Yeah, I'm looking forward to hearing his argument about the, yes, you don't have any privacy anymore, because I think that's what he's going to have to argue.
Yeah, that's what he's about to say.
Judges, yeah. Okay, well, I'll let you go.
If you rule that this behavior does not require discipline, that's bad precedent. That will cause problems in the future. Justice Stegall, I would respond to your suggestion, your hypothetical suggestion, that this is very different. The whole purpose of this particular website is to send your photos, these nude photos, out to other people who you don't really know. So this is not the same as sending a message to your wife saying, let's have lunch at the Classic Bean. This is completely different.
Do we have to, and I appreciate that difference, and that's a point worth exploring, because I think this, where we draw the line between public and private is, at least from my perspective, one of the most important things about this particular case, because it has such wide-ranging implications for society and certainly for members of the judiciary. And so my question is,
okay, that's funny, Philip.
You're essentially suggesting that there should be some kind of a foreseeability element to this. Like, if I make a private communication, you have to sort of assess the risk level of exposure. That's kind of what you're saying, right?
Well, I still would refer to, I think one of the other courts talked about the fact that all of these other issues aside, when a judge is grooming his private organs for purposes of taking a photograph and then takes those photographs and tries to claim that they just accidentally slipped off out of his phone when he was talking to a woman, that there's just no justification for that as being private. That goes beyond private. The whole point of taking those pictures is not for him to look at himself. He took those pictures to give to other people. And the same would be true.
But it seemed as though the panel drew such a wide net to what is public by anytime anything is shared at all. And you won't get any argument from me about the disturbing nature of the conduct here. But I'm having a hard time seeing how we draw the public-private distinction based on the content of the communication. It seems to me the content of the communication cannot play a role in deciding whether it's private.
Well, I would say the content can, because in this particular case, there are gross, vivid descriptions about having sex in chambers. Now, that is related to the judiciary directly and absolutely. That's not a private matter. So the content does relate to whether it's public or private. And I would encourage you, before this opinion gets written, to go back and read those text messages about sex in the chambers and ask yourself, is this a private matter? This is with a lay person in which.
Well, I'm sure it's a private matter. He's just saying those texts are filthy. Take another look.
This is where sorry, I was listening to it while I had to walk away.
Right.
He was doing so good, but now, once it turns into this, you have no privacy, and they are, he hasn't brought God into this yet, but he's like, the authority of the chambers, and it's, and he dare sully the, rich common law history we have.
I mean, this is tough. This is like a good thing for people to see. Yes, I got it because it was salacious. Yes, because and it's funny. Okay, fine. But it really
I was with him
raises
till this point.
very interesting questions about what are the contours of this stuff. Because on one hand, this is embarrassing to the judiciary. There's no two ways about it.
Oh yeah, I'm sure these justices would have been like, "Look, come on, Marty. Like, why did you have to bring this to us? Like, why did you have to do this?"
But on the other hand, who wants somebody peeping on everybody's stuff? I mean, it's so it's this is a good fight that should take place. Yes. And I don't have a clean answer to it.
I don't either.
Yeah.
Tells her where from another state, which he tells her where his chambers are, and then they talk vividly about what would happen if they were together in chambers. So,
Todd, that's how it's done, buddy. Yeah,
Well, if you're in state A and I'm in state B, you really can't affect me.
Yeah.
So I don't know.
I like to talk vividly about it. You don't do dirty talk vaguely, Todd. Let me just explain this to you.
I also heard a photograph as a phrase. There was not a photograph. There were a multitude of photographs, multiple photographs. So this wasn't the case of sending a photograph out. There were multiple photographs of both men and women sent back and forth by this judge to and from this judge.
Well, that's how it's done.
Yeah, they were doing things I didn't know was legal. He's like, I've asked my wife about this. She says it's not possible. So I'm really confused.
Oh, he keeps going with the multiple thing. It's like, this isn't, it's sort of a binary scenario. Either you can do this and do it a lot, or you can't do it at all. That's how it is.
Yeah, I think that's kind of my point, too, at the end of the day.
Right.
Either it's good if I do it, or it's not good. There is no...
Right. Yeah, you were saying that from the get.
So I would suggest this. The panel has recommended public censure. That's the absolute minimum that is required here. I would also note that the respondent is in his early 50s. He has the ability to run for this position again, which would be unfathomable to me. I understand the Romy situation, but in this particular instance, I'm not sure just admonishment is appropriate. I would suggest that there be some additional criteria applied that would preclude him from ever being a judge again unless he has had a great deal of education about the role and about the integrity of the judiciary. Thank you.
Mr. Thompson, your last remarks kind of, I think, tell me the answer to my question. But again, I'm focused at the top of page 12 of the final hearing report that talks about posting, and it just says a picture, but I don't care about that. But post the social media website. If you take the social media website out of this case, do you still have an argument for public censure of this judge?
Again, great question. Great question.
Well, I would argue this is a social media website. It's not an unlimited one, but it is a social media website.
Take it out.
That's an implicit no,
of the
but okay.
Picture.
Okay, so if it's...
That didn't happen.
I've made that argument myself.
He still distributed photographs to members of the public of himself, of his genitals, to people he didn't really know. Initially, he posted these pictures and gave this couple the right to access them after meeting them one time.
That's a moral
after
judgment.
meeting them one time. Like, how well do you have to know them before you start sending pictures of your junk?
Well, this is where like people keep pointing out. It's like, Todd, you should definitely not. Hopefully, nobody's told Todd about Tinder. It's like, what? You just unsolicited. You send out pictures.
Yeah, absolutely.
So yes, it's still inappropriate behavior. Just taking pictures of your genitals and distributing them in any way to the public, in my opinion, does nothing to enhance the integrity of the judiciary.
I don't know. Have you seen the pictures?
Are there other questions?
I did just have a quick question. that I remembered as you were closing. But what is your position on the jurisdiction now that the judge has voluntarily retired?
I think the jurisdiction question was answered in Henderson 2 very clearly by this court. If I can grab that real quickly, I'll quote you guys in holding that the judge should not be able to escape by simply retiring. The respondent, this is
yet another interesting issue. Do we have jurisdiction to do anything over the guy now that he's retired and he's not an attorney? They're hitting them all.
your quote in Henderson 2. The respondent suggests this court lost jurisdiction over him as a result of his resignation from his judicial office. This argument is inconsistent with prior decisions of this court and with the policies that govern the discipline of judges. So, and then it goes on, you go on to cite other cases.
We also found
you clearly have jurisdiction.
We also found that because Judge Henderson was no longer serving as a judge, we lost the capacity to sanction him.
Well, no, you lost the capacity to remove him from office. You
Well, and to suspend or to sanction him, and we didn't do anything else.
Yeah, there was no sanction imposed.
Correct.
Mr. Thompson,
Ooh,
your
corrected
proposed
like that, bro.
discipline raises a question
Get fucking
of, in my mind, of what authority there is that a Supreme
I will, but it'll be somebody else.
Court has the ability to bar anyone from future office.
I think it does raise that question.
Oh, hold on,
I don't
Mike, let
believe
me
that
just show
question
something
has
real
been
quick.
answered, although the
Mike,
code.
hold on, pause real quick.
Yeah.
Okay, that guy who asked about the nudes. Hey, tonight 9:30, I do a stream. Every $500, every $500 super chat, I'll send nudes for you.
Are you seriously doing a live stream tonight?
Yeah, we'll do a guest hosting with guest host COVID-19. But yes.
Oh, fantastic! Go over to Potentially Criminal and check it out,
Yeah.
everybody, and hit like and subscribe while you're over there.
Yeah.
Specifically
Let's see how serious
states
Cactus
that
is.
you may impose any other remedy that justice requires.
Are there other questions? All right. Thank you for your arguments today. The court will take this matter under advisement. The court is in recess until 9 a.m. tomorrow.
Ooh.
Well, there you have it. There's the great Kansas Supreme Court swinging judge debacle.
Did they put that up on their own, Kansas Supreme Court, or no?
That was sent to me.
Oh, okay.
And I will say, I went the extra mile for my viewers because I am nothing but hardworking.
Yeah.
And I spent 12 seconds Googling this. And you know what the Supreme Court did? Because right in that clip, they take it under advisement. But you know what they did?
They sealed it.
They took no further action.
Oh, that's.
In other words, they gave this guy nothing else.
I think that's fair.
They let it walk. So he lost at a prior level. They didn't file exceptions, which I'm guessing they're saying they didn't appeal that decision. So there's a decision against him, but no consequence or sanctions.
It sounds like
I don't
it's
know
just stayed.
Yeah.
Which
So that's the result. That's the result. I Googled it. I have it here. If I was good at well, let me see here. Let me see. Let me see if I can do this. Is it on?
You have the newspaper.
Okay. So here's where we are. Kansas Supreme Court takes no action against former Judge Marty Clark.
Yeah, and I get, and I was saying this earlier, I know in some states you can be a magistrate or like a judge without a law degree, but the idea you can run for the office without the degree, that's
insane.
Yeah, and I'm not trying to say we're gatekeeping, but like you got to have some sort of legal knowledge if you're going to be in charge of stuff.
Yes, if you're going to be elected.
Yeah.
Like
I think you're a magistrate.
Yeah, we're going to appoint a magistrate to handle traffic matters and stop signs and that kind of thing, and then you can kind of pick them and like maybe they're trained for some reason or another. But yeah, they shouldn't be able to. They shouldn't be able to get elected to that. I agree with you.
Yeah. But that's very common in a lot of county or a lot of states actually.
Why?
I don't know. I think it's just get back to the old days, when there weren't a lot of attorneys, and it's like, oh well, Farmer Bob's trustworthy. Let's let him be the magistrate.
Stop it, Night and E. No, there is no shortage of attorneys. Yes, most attorneys don't want to handle petty traffic. It might be money because they can pay these guys nothing.
Yeah, maybe, but yeah, I mean, like in Ohio, if you become a magistrate, and I mean that's good eating. I mean, I bet it's like that in Illinois as well.
I'm in the city, so it's not like I know.
Well.
I mean, I get out in the hinterland once in a while, but not enough. And when I do, so let's say I'm traveling to Effingham, which is a farm town out in the middle of nowhere. Okay, fine. So, but why am I there? I'm there because I've got a really good case, and that's why I'm willing to travel there. So it's not being handled by a magistrate.
Yeah.
I'm not going out. I'm not going to Effingham to deal with somebody blowing a stop sign. Hell, I'm not even walking across the street to the Daily Center to do that. So, that's the way it is. Well, thank you for coming out. That was kind of fun. That was a weird one. Somebody just emailed that to me today, and like I said, I thought this was going to be like funny. I thought it was kind of funny. It turned out very funny. Like Joe and you were cracking me up. Even Ron earlier, but like I thought, oh, this is just gonna be super funny, and then I started watching and I'm like, no, this is super interesting. All the good arguments were presented.
Yeah, there's always, I mean, and I think this is just the proof you can have a hilarious situation, but also have that, that intellectual discussion about it and the underpinnings of it. And I do, and I think the court. And I will give the court credit because those are all boomers. They understand we are at a crossroads where, this is 1992. I'd understand, sanction this guy, do whatever, they stone him or whatever they do in Kansas. In Ohio, they probably would have done the same thing. But I think they're understanding, like, look, the world is vastly different even in the past 5 years. Maybe we shouldn't be involved anymore. I guess
that's where I was impressed. They're all sharp. All of them involved. All the attorneys, all the justices were bright people, and how on top of all of the issues they were. And I'm judging that based on their questions.
Yeah,
they were asking all the questions that I had.
Yes,
and I'm like, okay, this is kind of, I don't know, reassuring or something.
Yeah, they pushed back in all the places I was hoping they'd push back.
Yep. All right, cool. Well, go get yourself ready for your stream. What time is that at?
9:30. Oh, by the way, I know Team Skeptic. If you're still out there, I've been trying to get in touch with you through our friend Rennie. So don't be afraid to give me a shout. Then it sounds like we're missing each other.
Do you have his contact info?
I have his email from like if you go to like his about page, but other than that, no, I don't have his I don't have his DMs. I can't slide into those.
Right. Because I can get a whole Team Skeptic.
Okay, well if you can,
we bonded over Tuesdays and whatnot.
Yeah. Oh, and by the way, somebody who said I'm single. I'm definitely not single. I am happy with my situation right now. So. More than thrilled.
Oh, I love it. That's what happy hour is all about here at Law Talk with Mike.
Yeah. Oh, and somebody double diver Navy vet, he said, yeah, there's states that allow reading for the law. That's not what we're talking about. We're talking about literally like any of you could be a magistrate.
Yeah. Reading for the bar like California allows it.
Yeah.
You literally have to pass the bar exam, and when you do, you are a member of the bar.
Yes.
And subject to all of the stuff. I mean, when we get admitted, we have to go through what's called character and fitness, and that's where it starts, and then it's ongoing from there. Yes. I mean, that's the hard part, but then anytime you mess up after that, well, let's not go that far. Anytime you mess up and get caught after that, it could come back on your license. That's it.
Yeah. So yeah, it's an entirely different situation, and even with the past reading law thing, most states you have to do like a year of law school still, or you have to go. Like I think New York is one of the big ones where you still have to take a year of law school at some point in your reading for law. I don't know what year it is, but you have to take some classes, and then there's a bunch of states where it's like you have to clerk with like a judge or somebody who's like a certified attorney, at least for a little while, like an actual certified, like we trust you to.
Right, but the vast majority of states just don't allow it. Period.
Oh yeah. It has not.
Illinois, for instance, I'm not even sure, but like I know of nobody who's ever done that procedure. I'm not familiar, and I'm here all the time, so. I think Illinois, you have to be a graduate of an accredited law school, pass the bar exam. That's it.
Yeah.
The other funky things like Wisconsin just says, "Hey, you already passed the bar exam if you pass law school." In Wisconsin only.
Yeah, that's ridiculous.
So there's lots of like intricate local rules, but the broad perspective is you got to go to law school, then pass the bar. That's what 98% of us do.
Sure. Hey, Mike, I got to go. I got a phone call coming in.
Have a good night.
Have a nice night, everybody.
Well, thank you all for coming out. That was fun. I hope I did not miss any super chats. I was watching the whole time. I was trying to set it up so Yesenia could star the super chats for me, but we couldn't figure out how to do it. I even had a little meeting with her, a couple minutes before, and I can't figure out how to do it. She didn't have the ability to do it, and whatever. That's too inside baseball, but that's where we are. That was a fun one. Thank you all for coming out. I really appreciate it. See you soon.